Buenas noches. Happy Friday, everyone. I am so happy to see everybody joining in on this Friday. The weather is changing. There are more vaccines available, and we're here to learn more about how we protect our homes, how we assert our rights. And again, I'm very, very happy that you guys are joining in. As an organization, we make sure that we bring you guys top-notch um, folks that are going to speak to you. That are going to deliver to you the tools that you need. And today is a special day for us, for Palante as an organization, but more for me as a founder of this organization, because today we have two women that have really taught me a lot. They probably had a lot to do with inspiring me to do what I'm doing at Palante Harlem. And I'm doing it because I've seen, I've seen how HPD works. I've seen how HPD protects our homes. I've seen how they go after landlords when they are behaving badly. And again, the thing about Palante is, in the Zoom calls is that we have been able to get some great strategic partners that come in to help us, especially on a Friday night. So as I said, I think I'm very, we're gonna have a great seminar tonight, and with these two wonderful women who I highly respect, and we're gonna talk about what exactly does the city, meaning HPD, does when a landlord is behaving badly. And when I say, when they're behaving badly, we're not saying that they're saying, hey, give me the rent. No, no, it's not that. That's not the badly part. The badly part that we're talking about today is specifically when there are conditions in your apartment and those conditions are not being addressed, either by the super, by the property manager, who again represents the landlord. So anybody who works for the landlord is the landlord in our eyes. So I'm not going to take a lot of our time and talks about, what we're going to be talking about, because again, it's always been an open forum. But I do want to point out that you have the deputy commissioner of HPD, of the code enforcement, and you have the top attorney for Manhattan, for the borough of Manhattan, that focuses on litigation. Lynette is actually the supervising attorney of housing and litigation. And Anne Marie Santiago, who you see with a nice purple shirt, a blouse, is actually the deputy commissioner of enforcement and neighborhood services, both at HPD. So without further ado, Anne Marie, welcome. Thank you so much again for joining us, and Lynette, again, thank you so much for agreeing to come in and help us really talk about what you guys do on the back end that we don't get to see, because normally we just hear the, oh, I called 311, 311 showed up and nothing happened. And we know as an organization that you guys are effective, but it's also, we also have to do our part in making it and working with you guys so that it is effective. So without further ado, Anne Marie, go right ahead. Thank you.
Good evening, everybody, and thank you for inviting us. I know every year HPD staff usually come to your events. I know Lynette has gone several times to your in-person events, so it's nice to join you via Zoom this evening. Um, so what I'm going to focus on to start with is, just as Alcia said, what the process is for you once you've notified your landlord and or super, whomever is your landlord's representative, and they have not been responsive to you. So that's always your first choice. Once they've not been responsive, you should call 311. And you don't just have to call. 311 is accessible online. If your complaint is about heat and hot water, you can do it from your phone. It's called 311 mobile. So there's plenty of ways to reach 311. They have interpreters, they're open 24/7. There's no reason to not let them know how things are. So once you call them and you provide your information about what your complaint is, your address, your telephone number, please do provide some way for us to contact you. I know a lot of people like to file anonymous complaints, and that's okay if you're concerned about, your landlord thinking it's you filing the complaint. But it's really helpful for us to have someone to go to at the building when we go, and to not just have to knock on every door, which is what we do for anonymous complaints, because we don't know where exactly the problem is. When you file a complaint, 311 almost automatically sends that complaint to HPD. It happens in real time. And what we do is we will try to get in touch with the landlord, and we'll just let them know that we've received this complaint. We don't ask them if they fixed it or not. We don't close your complaint because of anything that they tell us. It's just a notification, because our job is to try and get that repair done as quickly as possible for you. And the person who's most likely going to do the repair is the landlord or the super. So we let them know. We may try to contact you by phone to say, was it fixed? If it wasn't, we will come out to the building and do an inspection. Or if we can't get in touch with you, we will come out to the building and we will attempt to gain access to your apartment. Once our inspector comes, they're looking for 9 different issues in your apartment besides whatever you complained about, if your complaint is not on this list. And we do that because we're concerned to keep you safe, for fire safety reasons and for health reasons. So we don't want to alarm you when the inspector asks you, do you have a child under 6? Or do you have a child under 10? The reason we ask those questions is because if you have peeling paint in your apartment, and you have a child under 6, we're trying to keep your child safe from lead-based paint, which is a health hazard for your child, right? If you have a child under 10, we're trying to keep your child from falling out a window. In New York City, window guards are required if you have a child under 10. Those are 2 key items that we want to make sure, regardless again of what you called about, once we're in your apartment, we're going to look for those things. We're also going to look for smoke detectors and carbon monoxide detectors. We're going to look to make sure that your windows don't have fire safety gates on them, or your doors have locks that require a key to get out, all fire safety issues. We're going to look for mold, and we're going to ask you, is there mold in your apartment? Are there pests in your apartment? Are there mice and roaches? Once we do that and we walk through your apartment, we will write our violations. The inspector will write what he has observed or she has observed. When the inspector comes, you should expect to see someone in a uniform, right? The inspectors have a badge, they have an HPD ID. You can ask to look for any of those things. Now with COVID, the inspector should be wearing a mask, and they will ask you, if you're not wearing a mask when they come in, to put your mask on as well. We're trying to keep everybody safe and not spread COVID from apartment to apartment as we do our inspections, right? So please be helpful in doing that when the inspector comes. If the condition that the inspector observes is an emergency condition, and by that we mean is immediately hazardous to you, lead-based paint is certainly one, but if your ceiling is collapsing, if you have no electricity in your apartment or no water, if you have conditions like really bad mold in your apartment, the inspector is going to write that as what we call a Class C violation. And those violations, if the owner doesn't fix them, the city may come and get in touch with you to try and fix it, right? These are the most serious violations that we issue. Often the owner has a very short time period to fix it. If it's mold or it's lead, the owner has, by law, 21 days to fix that, right? If it's a serious leak, the owner probably has about a week to fix that. So understand that when the inspector comes, the law does provide some opportunity for the owner to correct, and the owner should correct. That's the entity that we're holding responsible to keep you safe. That's the person you pay your rent to. When the emergency repair is written, you may get a phone call from HPD. If you've given the inspector your number, and again, it's important for us to have your contact information. Even if you didn't give it when you filed a complaint with 311, when the inspector comes, please share that information, because we'll need to call you to be able to come. We have to send someone who's going to look at your apartment and write a work order. We have to have our contractor come back and do the work. And then we have to have somebody else from our staff come and make sure that it was done right. So there is a process if there's an emergency repair to get it done. And I know that that may take a lot of time from you, but the idea is you can't live with this immediately hazardous situation, right? It's not right. The city is there to provide this service and to help you. Now, the city doesn't just provide it out of the goodness of our heart, though. We do bill the owner for that at the end. So just know that your landlord, if HPD has to do the work, your landlord will be billed for that, and they will pay the city back at some point down the line. We want to make sure that everyone who gets an inspection gets the information that we give. So when the inspector's there, he may be giving you information about lead-based paint. He may be giving you information about mold. She may be giving you additional information about pests. Please read that information if you can, because it may provide some help for you to deal with the situation you're in until the repair happens. They should be giving you a general pamphlet explaining HPD's process. So we do millions of dollars of emergency repair every year. We restore heat and hot water. Again, we do lead-based paint. We put in window guards. We put in self-closing doors. So you may be aware of that big Queens fire that just happened a week ago or 2 weeks ago, because the door didn't close behind the tenant. That's an emergency condition if we come to your apartment and the door doesn't close when the inspector opens the door and closes it, right? That prevents fatalities in the event of a fire because it stops a fire from spreading. So these are the things that we're going to look for and we're going to follow up with you on. If what's issued in your apartment is a Class A violation or a Class B violation, and they're just less serious than that immediately hazardous that I've been talking about, you can get a list of all of the violations issued during your inspection by going to HPD's website. That information is always available to you. We're hoping to make the website a little more user-friendly in the next year or two so that you can also access it from your phone, because I know it's not really good for that at this point. But if you have access to a computer, you can certainly get that at any time, and it's updated every day. So if you wind up going to housing court, and Lynette will talk a little bit about that, or you want to address your landlord through Palante or some other group, that's your first stop in order to know where you stand today. What violations have already been issued to your owner? What has your owner done or not done? Understand that I also talked about that the owner has a period of time to correct, right? As a tenant, you have an obligation to allow your landlord access to correct it. So please be open to that as well. I know that there are some landlords, and I've heard tenants say many times that this landlord has fixed this 50 times and it's still broken because they don't do a good job. You should consider housing court as an option there if you're not satisfied with the quality of the work that your landlord is doing. So I'm going to turn it over to Lynette, if that's okay, and we can come back to me on Q&A.
Good evening. Thank you for inviting me to speak to you all tonight. And so I just want to pick up where Anne-Marie kind of left off and talk a little bit about housing court. So housing court, there are different cases that are brought in housing court. And specifically, I want to talk about the tenant action cases. These are the cases that you, the tenant, can initiate on your own. And it's really quite simple because in housing court, the clerk's office is designed to help tenants that do not have attorneys fill out the paperwork, fill out the orders to show cause, tell you how to serve the documents on the landlord, tell you the affidavits that need to be filled out when you need to come back to court. So once those documents are filled out in housing court, and housing court, each borough, depending where you live, in Manhattan, we're located at 111 Center Street. For the Harlem cases in zip codes 103.5 and 103.7, we're located at 171 East 121st Street. Harlem court is not open now. Neither is housing court really for in-person appearances, except in very limited situations. So, but generally, you would go to the second floor at 111 Center Street and complete the paperwork. Once that's done, you get a court date, and it's a rather quick court date. You don't have to wait weeks on end to get a court date. You get the court date, you appear in court, and prior to the court date, the clerk's office would set up a reinspection of your apartment. So what that means is that HPD, a HPD inspector will come to your apartment and inspect the conditions that you are alleging in your order to show cause. So if you're alleging that you have leaks, if you're alleging that you have infestation of roaches, mice, vermin, any condition that you allege, the HPD inspector will come to your home and inspect those conditions to see whether or not those conditions in fact exist. If the conditions exist, then the HPD inspector will issue a violation. And so there are different classes of violations that can be issued. The A violation is the less severe violation. And pursuant to law, those violations, they're 90 days, the landlord has 90 days to correct. There's the B violations, the landlord has 30 days to correct. And there's the C violations, which must be corrected within 24 hours of issuance. So anytime you get those violations, and once the case is in court, the HPD attorney will conference the case and will organize when the landlord is going to come and make the repairs in your apartment, pursuant to the statutory time frame. And as Anne-Marie said, it's really, really important to allow the landlord access to make those repairs, because the main reason you are in housing court is to get your repairs completed. And I know that many times it's very frustrating because, you know, there's this relationship that you have with the landlord in many instances is not positive, it's a negative relationship. But pursuant to law, it's really important that you give the landlord an opportunity to make the repairs. And if, for example, he's supposed to come on a Monday and he fails to show up, you document it. So document it so that if you need to come back to court, you can inform the court that the landlord was supposed to come on these days and never showed up. If the landlord comes on another day and you're available, give the landlord the access. Because you can say the landlord didn't show up on that Monday, he came on that Tuesday, and I was available. I gave him the access to make the repairs. The repairs were made, but it was a shoddy repair. And you can document it by taking pictures of the repairs that wasn't done properly. You can document the repairs that he didn't do at all, so that when you come back to court, you have more evidence to present to the court and to present to the judge as to why this landlord should probably be held in contempt of court, why this landlord should be, why civil penalties should be imposed on this landlord. So the stronger case that you have, the more credible your case is, the more credible you appear to the court, and the more remedies you have before you, and likely there's more of a likelihood that the judge will rule in your favor if you need to come back to court for contempt or civil penalties. And I know that in many instances, it is very frustrating dealing with the court system. But right now, I can tell you that the courts are really, really doing their best, especially under this situation with COVID. We're doing court every day. We're in court doing virtual cases. We're still doing trials. So it's still you still have the court access. One other thing I also wanted to talk about is the access warrants that HPD initiates on their own. So Anne-Marie also talked about allowing, when you have a complaint for heat and hot water or lead and violations are issued, what happens when we, HPD, determine that the landlord didn't fix those violations? When and will HPD endeavor to make the correction of those violations? So let's say an inspector comes to your building and the landlord does not permit us the access to make the repairs. What happens? Well, what happens is that HPD attorney will go to court in order to get access to the building or to the apartment to make the necessary repairs. And so we bring those cases on Class C violations. So that means that the violations are immediately hazardous violations. So if you have a boiler system that's not working properly, if you have lead, if you have leaks, a collapsing ceiling, any immediately hazardous violation, we will go to court and start a case to allow HPD emergency repair personnel contractors to come in and make the repairs ourselves, and we will then bill the landlord. And this process, we try to mainstream it and get the cases in court rather quickly so that we can address the repairs in a immediate manner. So that's one other important enforcement tool that we have is the access warrant cases. We also bring cases for heat and hot water, as you know, and for heat cases, those cases are commenced on October 1st through May 31st. Our inspectors issue the violations during that time, and those cases are brought to court, and we obtain orders compelling the landlord, the owners, to provide heat and hot water. Hot water is required, as you know, 24 hours a day, 365 days a year, without interruption. So we do realize that there are some instances where the boiler may need maintenance. And for that, of course, the owner has to post notices informing you that maintenance work is going to be done. And that's typical. So for those issues where the owner is doing maintenance work, you also need to understand that you really shouldn't be calling 311 for owners that are working on the boiler, making sure that it's kept up. And so you really shouldn't call 311 for those typical maintenance repairs. However, if it's ongoing and if the boiler is constantly down and you're not getting sufficient heat and hot water, you can call 311. Once we place the violation, those cases go to court. We receive civil penalties and fines. And we also, most importantly, we get an order to correct, compelling the landlord to continue providing heat and hot water. Lead paint, we do lead paint access warrant cases as well, where we bring those cases to court to go out and remediate lead paint, especially if you have a child under 7 years old living in an apartment. We will also do access warrants for those cases and also start cases to compel the owners to make those corrections with respect to those violations. And comprehensive cases, we initiate comprehensive cases, which are cases in which HPD attorneys will start cases for all. If you have lots of violations on a building, we will start a case to get violations, all open violations on the building corrected. And this is done by obtaining an order where the landlord says that he's going to correct violations in apartments and also in a public area. And one of the ways that we also do that is that we also try to compel them to make these corrections by also imposing civil penalties. And once we get the order, if they don't comply or adhere to the terms of the order, we can restore the case to the court's calendar, seeking further civil penalties and also contempt of court. So those are the main cases that we bring. But one of the things I guess I want to stress is the fact that you as tenants and you as tenant organizers, you need to be aware that you can also bring your own cases. And by bringing your own cases, you can sort of like say when the landlord can come to your home to make the corrections. And also the owners would also be under court order to make those corrections. And if sometimes there's an issue in court, whether or not the owner properly fixed the violation or not. And so when the case is restored, the HPD inspector can go back based on the fact that the judge made the request to have a judicial inspection. The HPD inspector can go back and see whether or not the violations were corrected and corrected properly. So, any questions?
And before we just turn over to questions, just one additional thing I want to add, and this is really, directly related to groups like Palante who work with tenants and tenant associations, right? Some folks are scared to call 311 and afraid to do things on their own, but it's you have strength in numbers, right? So if multiple tenants in the same building get together and either make complaints through the 311 system, as I just said, or go to your organizers and your organizers in your neighborhood, they can bring those buildings to our attention and we can look at the building, outside of individual complaints. It's always good to have individual complaints because sometimes LCO will come to me and say, I have this building's really bad, and 311 has no complaints and we have no violations. And so there's no way for us to help you if we don't know. If you know and you want to get together and people in the building are afraid to make individual complaints, these are the times when you seek out your community groups and you say, our building is really bad. We, for numerous reasons, we are afraid to let the owner know that we're complaining. Can you bring this to the attention of the city? And we will try and have someone go out there and at least take a general look. And then, to write a violation in your apartment, we obviously need to get into your apartment. And the landlord's going to know we've been in your apartment. I can't stop that, right? But especially for conditions that affect multiple people, if there are leaks in every apartment on the top floor, right? If there's no heat for everyone, these are situations that you shouldn't be living in. And we can only help you if you let us know that that's what you're going through. So I just want to give, not as a plug for Palante, but just to let you know, as tenants, you do have power as individuals, but you also have power as a group. So don't, fail to take advantage of that.
We
Also,
always,
I guess excuse me, I want to add on that note that with respect to the tenant action cases, you can also, tenants can come together and file these cases as a group action. So if you don't have to file it just by yourself. You can, your tenant association can file it as a group action, or a collection of tenants themselves can file it as a group, where each tenant can be named as a petitioner. So the tenant action cases, it's really a strong, forceful tool and mechanism that would allow repairs to occur.
so this is great, guys, and thank you for walking us through this. I have a couple of questions before we open it up. Anne Marie, can we talk about the C-class violations? The C-class violations, you mentioned that it's 24 to 48 hours. What are C-class violations? I know that once a tenant calls 311, 311 operator passes over the call or refers the call to HPD, right? Which is your division. And then from there, an inspector gets deployed. An inspector comes to the person's apartment, inspects the key things that you mentioned right off the bat, which is the smoke alarm, fire egress, the front door. But then after the inspector leaves, the tenant then gets a notification, right? Showing the class of the violation, whether it's an A or B or C class. So in the C class, can you just elaborate a little bit further on that? That what tenants are what should they expect? Because some of us, we're under the impression that if it's an A class or if it's a B class, HPD is going to come in and do the repairs, versus what HPD considers, or what the law considers are immediate hazardous violations. Can you speak on that a little bit?
Sure. So A and B class violations are less serious than Class C violations. And Class C violations are ones that put you in there's an immediate danger there, right? Or a more immediate danger. So lead-based paint is clearly a Class C violation. No heat and hot water is a Class C violation. Collapsing ceiling. So if your ceiling is falling because there's an active leak in your ceiling, that is a Class C violation, right? There are some Class C violations that are not emergency repair, so the city will not come. For example, roaches and mice are now Class C violations. The city will not come and do extermination because extermination requires a really long-term commitment to making sure that you have an exterminator come and he plugs all the holes. Like it's an involved process. It is not a quick fix for pests usually, right? For heat, even for heat and hot water violations. So if the temperature in your apartment is 66 degrees, you will probably not see emergency repair, even though that's a Class C violation and it is against the law, and we may issue a penalty and we may seek a penalty. When it's cold and it's below, 65, 64 degrees, you will get a call from HPD, from emergency repair, saying, we're going to come out and look. Or you may just see someone from emergency repair come to the building, or you may not see them. So this is, I think, the important point. For conditions like heat and hot water, the inspector, the technical person who comes from emergency repair, may just go straight to the basement and attempt to see what's wrong. So they may not come back to your door right away. That doesn't mean that they're not out there. We respond to heat and hot water pretty quickly with emergency repair.
And now that you mentioned that, Anne-Marie, sorry to interrupt you, but now that you mentioned that, so when the inspector comes in and tries to get access to the basement, if he cannot get access, then Lynette's group goes out there and sues the landlord to get access. That's what's called
they can get. Correct.
Right.
So Lynette talked a little bit about that. We can try and get an access warrant. That's called an access warrant, right? We go to the judge and we say, Judge, there's no heat and hot water in this building. We need to repair it because the owner hasn't. So get an order to either the owner at that hearing, at that court appearance, can either say, no, Judge, I'm going to fix it. And the judge, is monitoring that then. Or we get a warrant that says HPD can go in and break the lock, go into the basement to make the repair. So we do get access warrants during the heat season for heat. For other emergency repairs, usually we don't get stopped by the landlord, although it happens for lead, as Lynette said. But generally, it's about making connection with the tenant and making sure that we can get back into the apartment, right? And again, as I mentioned, it's unfortunately a number of visits. And for some folks, they get tired of hearing from us or they don't call us back. Just like everyone else, if I get a call on my cell phone and it's not a number I recognize, I often don't answer it, right? And so unfortunately, we can't put like your HPD emergency repair is calling on your phone. So you need to check and see if you expect that the city should be coming back. Check your phone regularly to make sure we haven't left you a message to say, we're trying to get in, please, respond to us. We make 2 attempts to get into your apartment to do that emergency repair, and then we send you a letter. Okay, we send a notice. The notice is in English, Spanish, and a couple of other languages on the back to say, please call us. We've been trying to get into your apartment. Please call us to make that appointment. And what I would recommend is, even if it's not an emergency repair for a condition that you called about, so say you called about mice and roaches, we wrote an emergency repair for the window guard, call us back and let us put that window guard in, right? Or we wrote a violation for mold, but you called us for heat and you didn't really think that that was a problem. If we wrote the emergency repair, please call us back. We do want to address that condition, both for you and for your building, because sometimes some of these conditions can continue if the leak isn't fixed. First, it's just in your apartment, and then it's leaking downstairs in the apartment below you. So it's very important for you to get back to us. Usually we will leave, if we're calling from our emergency services bureau, we may leave a main number. If we're calling from the folks who actually have done, would be coming out to do the repair, we'll leave a different number for you to call. It's very important for you to get back to us.
That's great. So let me quick question. So when we organize these buildings, I've always been curious to ask this one question. When we organize buildings, we tell them we're going to do a 311 party when there's no heat, for example. Everybody sees their cell phones. Everybody calls 311 at the same time. Does that get to you guys like, hey, all does it like light up like a Christmas tree, saying all these people are complaining at the same time? And does that have an effect on the response time, like when tenants organize as a group?
For the most part, we try to deal with heat as a first in, first out situation, because we do know that, you could be just as cold in a 3-unit building as in a 20-unit building, to try and get people out there. But our response time this past heat season was really 2 days or less in most cases. So we really are trying to get out there quickly. And in terms of heat, again, I know people don't want us to let landlords know that they don't want the heat turned on just because you call 311, but it really is in your interest and ours to have the heat turned on as soon as possible.
Yeah.
And with our quicker response time in recent years, that window has shrunk for owners to be like, well, I know it takes HPD 5 days to get out here, so I'm going to leave the heat off for 5 days, right? Really, we are getting out there within a day or two, thanks to new technologies and new things that we've implemented to respond to heat complaints.
And if the landlord is playing these tricks, it's a good point you mentioned that they can actually tell the 311 operator. The landlord likes to turn off the heat around 11 p.m. every night when he knows that it's going to take a day or so. And I know we've done it. We've actually alerted HPD to the 311, and inspectors are deployed during that time.
That's correct.
But it's important that the more the tenants that call, the more validity you guys, the groups have, each building would have.
Understood.
Right?
Yes.
So,
and it's
sorry,
important too, when you have no heat, to be as clear as you can about when there is no heat. So I think you have an option when you call 311 to say there's no heat only in the morning, or there's no heat only in the afternoon, or there's no heat all of the time, right? And really, if you have no heat all of the time, those are the most serious conditions for us, because that's when pipes freeze, that's when the temperature drops very low for the entire building, for the remainder of the time. So that's also one of the ways we prioritize response.
So then when the inspector comes in and issues a violation, does the landlord get fined? Does he have to pay money for that before he gets to court? Because I know in Lynette's department, he's going to have a big fee that he or she is going to have to pay. But when the inspector comes in, where there's an A, B, and C class, do they get a monetary penalty?
So there is a fee structure, but it's not for every inspection. So it's a little involved for me to get into on the call, but I'll use heat as an example. So for the third heat violation, if an owner gets 3 or more heat violations, they start getting automatic fees of $200 for every inspection that results in a heat violation, right? So that's very specific to heat. There's a similar process related to non-heat violations. So again, if you are in the same apartment and you're writing violations within a certain period of time in the same apartment, the landlord will also get fees. So if you want to see the specifics of it, we do have the information on our website. But there is that, and if the building is an AEP, obviously there's additional fees as well in our alternative enforcement program, which is a different type of program for the building wide. But there are these fees that the city council has put in place, and what happens is those fees are automatically put on the landlord's tax bill, actually property tax. So once something's on your property tax, you really can't get away from it, having to pay it.
So although we might not see that the landlord is getting hammered with these violations, obviously all we see is that he's not coming over to make the repairs, the super's not coming over, but there is the other side, the enforcement side, which is accumulating more fees that could potentially turn into liens.
Yes.
Right. So it's not, so for tenants that have, like they said, the A and the B class, right, that does not fall under the emergency repair section, then they, like Lynette mentioned, they can go to court and file what's called an HP action. It's HP stands for housing part. But then Lynette, what does HPD do when a tenant takes the landlord to court? Is there a representative in court from HPD that they can talk to, or can you walk us through? Let's assume that COVID is not here, right? And these were normal circumstances. Can we would it be fair to say that when a tenant sues the landlord, did they have any help from HPD on the side? Does HPD get involved, or how does it work?
So when the tenant sues the landlord, the tenant shows up in court. And when they check in, we normally ask if they have an attorney. And if they have an attorney, we're not so much involved because they have an attorney. If the tenant is pro se, meaning that they don't have an attorney, Then we conference the case with the tenant. We find out exactly what's going on, what repairs are needed, what repairs was done. And we sort of get a sense of, what's going on between the tenant and the landlord. Is there any animosity? Is there an issue in terms of access? That kind of thing. And then we look at the violations that's been issued, and we essentially tell the owners that pursuant to law, they have to correct the violations. And then we, give access dates when they're, when the owner is going to come to make the repairs, when the tenant is available. So we are a presence in the courtroom, and not just HPD, but there's also court attorneys that deal with the tenants as well, and they conference the cases with the tenants. And then lastly, the judge. So of course, if you're in housing court, you do have the right to see the judge and explain to the judge any issues or concerns that you may have in terms of getting the repairs done. So housing court, I want to say it's tenant friendly in the sense that there are these different kinds of HPD, the court attorney, the judge, and court personnel that's there to assist the tenant in resolving the case.
This is great. This is awesome. So when it comes to HPD, I mean, I'm seeing some of the questions. I think it's important that we understand that there's different divisions within HPD. The division that we're talking about are the enforcement side. HPD has an asset management side. They have a loan program. They have the affordable housing. They have a lot of stuff underneath their umbrella. But today we're speaking specifically on the enforcement side, and with Anne-Marie Santiago and with Lynette Parker. I think that, historically, it's been that when a tenant has complaints about the apartment, they tell the landlord, nothing happens. The tenant are not they do not go to court to file an HP, right? But I think that people don't, they don't know how cheap it is to actually file a lawsuit, which is only $45, I believe. And that there is help, there's actually support, there are resources within the courts that can assist even further. And we try as an organization, we try to educate as many residents as possible, let them know the process of it. But let's talk about real quick on the Anne-Marie's umbrella. She's got the Division of Alternative Enforcement Program. So those are basically, is it the top 200 buildings in all New York City that are in the worst conditions, Anne-Marie?
250 each year are selected.
250. Can you tell us a little bit about that?
Sure. So
how do they get on that list? Like, for example, how do they get on that list?
So the city council wrote a law probably about 15 years ago now, defining what a bad building is for AEP purposes, right? And what it really looks at is how many violations are open at the building for the number of units that the building has, and how much emergency repair work has HPD done in the building. So this kind of circles back to you have to let us know when there are conditions in a building. Generally speaking, when we're responding to one complaint, we only go to that one apartment. We don't go and knock on every door and ask every tenant if they have issues. It's not feasible for us while we're trying to get to the people who are complaining, because New Yorkers, everyone complains. So, but that doesn't help get a building into AEP, because if only one tenant is complaining, the building will likely never meet the threshold of how many violations you have to get into an enforcement program like AEP, right? We really need people to bring to our attention the conditions. So based on how big your building is, you basically have to have a certain number of violations to be selected for AEP. A smaller building has to have less violations. A bigger building has to have more violations. So we do that every January. We select those buildings. And then what happens to them is they are looked at by a small team, a dedicated team of people who go to the buildings and really our intention is to get to the owner to bring the building to a good condition within 4 months. That's the first milestone for AEP, right? So we tell the owners, you make all the repairs, you pay all of your ERP charges, you register your building, and you can get out of AEP. If you fail to do those things, because of course we want the building to be repaired as quickly as possible for the tenants, if you fail to do those things, you will be hit with significant fees. And that's what happens, right? $500 per dwelling unit is what's charged to the landlord automatically if they fail to get out of AEP
Dwelling
within
unit means
4 months
apartment, right?
per apartment.
Per apartment.
And then if still 6 months later, they're still in AEP, we charge them another $500 per unit apartment in the building, right? So this is an incentive for the owner to get themselves together if the fact is that they're not the worst of the worst and really just they don't care about the money. Most owners are very responsive to that because, again, for your bigger buildings, it can be a significant amount of money that gets billed to you.
And then there's that other, and I think it's a great program because it pretty much the way I'll put it in my layman's terms, it in order for a landlord that's behaving badly, the only thing that would incentivize him to change his behavior is the money in his pocket. So if he's getting fined for not being responsive, eventually he has to do something. But and in the event that he doesn't, like we operate heavily in West Harlem, and we've got some really small, really shady bad landlords in our community. What happens if they just don't get anywhere with the AP and they're like, you know what, I'm just going to abandon the building? What happens? What happens if they abandon the building?
So before we get to the point, hopefully, where they've abandoned the building, we might turn the building over to Lynette. And in addition to AEP, we might take that owner to court and seek additional penalties there, right? If a building is truly abandoned, right, and it's really in poor condition, we may look to our 7A administrator program, right? If the person isn't paying taxes, a while back, they could have gotten into the third-party transfer program. I'm not exactly sure where that program is right now, right? But the idea is to see what can be done to move the ownership of the property or the management of the property to a responsible party. So, the city is working on tools all the time to try to do that because we don't manage property anymore, right? Everyone knows the city many years ago used to take the property and then the city would manage it themselves, but we aren't necessarily that good at that. So the idea is to make sure that a professional management or owner comes into the picture. But also for buildings that don't get into AEP or buildings that haven't had enough violations, we have what we call a proactive preservation program, right? Right, yes. So this is for a building where you think it's really bad, but the numbers aren't there for us to put it into AEP because we don't sit and choose which buildings go into AEP. They have to meet the very specific criteria. So our proactive preservation program, we go out with our Division of Neighborhood Preservation, who does a preliminary walkthrough of the building with the tenants, tries to work with the owner to get the repairs made, and if that doesn't work, then we send code enforcement and we proactively will knock on every door and look in every apartment and write the violations that exist. We also have an anti-harassment unit now, which is only a couple of years old, but which basically also takes referrals, works with tenants who report that an owner is not doing repairs with the intention of harassing them to leave. And so these buildings, we also choose buildings ourselves for the anti-harassment unit to go to where we see that maybe violations are on the rise, right? Because we want to get to buildings ideally before they're bad enough to be an AEP. No one wants to allow a building to deteriorate to get to that level. So this is kind of a mid-intervention. And the anti-harassment unit will also knock on every door and do inspections where tenants will give us access to do so.
This is excellent. So when they don't follow the AEP rule, right, or when they don't follow the neighborhood the PPI,
no,
then it goes to Lynette. Lynette, can you talk about that comprehensive cases?
The comprehensive cases are really important to HPD. And it's important in the sense that we look at the building, we look at the violations on the entire building, and we look at the units to see how many units the building has. And we bring these cases to court with the goal of getting an order to correct on these buildings, the open violations, getting order to correct so that the landlord can make the repairs in tenants' apartments, individual tenants' apartments. And if there's any violations in the public areas, the landlord has to make those repairs as well. So it's a good tool to get the entire building violations corrected that are outstanding on that building. And it's really important because it's sort of like the opposite of a tenant action case where the tenants are just bringing mainly violations to get corrected in their individual apartment. We're bringing a case to get violations corrected on the entire building. And so that the tenant can have a sense of, feel good about where he lives or they live entirely, not just the apartment, but the public halls, making sure that the windows and everything in the building that has violations, to make sure that those particular violations are corrected building wide.
Are tenants allowed to participate at these court meetings, court sessions?
Well, sometimes we do contact the tenant. We may need the tenant as a witness in some instances. Sometimes we may need to get a tenant affidavit. I mean, I've gotten that in most recently to support the fact that access wasn't an issue. So there is some tenant participation in these cases, but generally, we don't need the tenant, because the violation is what's considered evidence that the condition exists, and the landlord has the legal obligation to make the repairs.
Well, this is great. Sometimes what happens behind the scenes is really amazing, and I thank you guys for really looking out for our community and doing all this work, because we know what we're dealing with in our community here in terms of the lack of repairs, the conditions. So I thank you, and I tip my hat to you guys. I think we're ready for questions. I'm going to ask Robert to join in, because I have a bunch of questions, but I want to give people the opportunity. Robert, do we have any questions queued up?
We have several questions, and they just
Terrific.
kept on piling on as
I'm
the
sorry. You
the
need to text me
presentation
next time.
continued. No, it's wonderful. I hope we get to all of them. And just sometimes I see a hand go up, and maybe you hit the hand by accident, but just keep in mind the Q&A is there and the chat is there, and I'm monitoring that and collating everything. How can a NYCHA resident keep their landlord accountable?
So HPD does not respond to NYCHA complaints. So I'm going to have to punt a little bit on that one. NYCHA has their own complaint system. However, tenants in NYCHA can request through housing court for HPD to do an inspection. And in that case, the court will receive a report of HPD's findings. And so the court can then order NYCHA to make the necessary repairs. But as a matter of course, you cannot call 311 to file a complaint with HPD for NYCHA.
I just want to add also that, of course, NYCHA, HPD does not appear in NYCHA cases. However, you can file your own case in housing court. There is a separate part in housing court that deals with NYCHA cases. And they also issue correction orders as well, or having NYCHA making the repairs, the necessary repairs. So there's still a process in housing court for NYCHA buildings.
All right. Landlord is summoned for if a tenant calls 311 or just for violations found during the inspection. Can a landlord file an eviction against the tenant for calling 311?
So I'll take the first part of that, and then I'll leave the eviction for Lynette. HPD does not issue violations, and at HPD we call them violations, not summonses, for complaints only, right? A complaint is an allegation that something is done wrong. Until our inspectors see it and observe it, we will not write a violation. So that's the answer to the first part. You know, I'll start, but your landlord, because you filed a complaint, is not an eviction reason. That doesn't mean that landlords won't try to scare you with that tactic, but that is not the basis for an eviction. And so I'll let Lynette finish that.
And so that's correct. And many tenants are dissuaded from, filing these 311 complaints in fear that the landlord will retaliate. But really, that's not a reason for an eviction. So just be aware that you can file a complaint. It's not a reason to get evicted from your apartment. And if the landlord is trying to do this, then obviously you should seek legal counsel. There are many not-for-profits, legal services out there that you can consult, because it's illegal for the landlord to do that.
If a landlord files an eviction, you should call 311, and 311 will put you in touch with the mayor's office to protect tenants, which will provide you with, if you qualify, provide you with a direct contact at a legal services organization that can help you.
And moving on to the next one, how about when your water is brown in the bathroom and kitchen? How do you know if it can make you sick? Who do you call?
So HPD doesn't do water testing. If you have concerns about the quality of your water, you can file a complaint with 311. I believe the complaints go to the Department of Environmental Protection.
That's true.
Can you talk about safety factors that exist in a building? Vagrants living in the laundry room that is out of order, access and regress doors are not secured. And in January, a woman was killed and her partner shot, who survived. Several 311 calls have been placed in addition to reports to HPD inspectors. And to this day, the building is not safe. Drug dealers continue to reside here, trespassing in the hallways with young adults hanging out daily using drugs. We have not received any resolution from management.
So, drug dealing, crime in general, vagrants in the building are matters that need to be referred to the NYPD, right? Those are police matters that we, HPD, certainly cannot handle and will not respond to. We should be, if you are filing complaints regarding the locks and the doors, we should be responding to those and issuing violations. Obviously, I don't know the specifics of your situation, whether the landlord is repeatedly fixing it and it's getting repeatedly broken, or whether there's been no attempt to fix that. But certainly, if you provide some details to Palante offline, we can follow up with the specifics at your building.
Right. And throughout the whole winter, we had to set alarms to be able to bathe with hot water from 2 a.m. to 6 a.m. The water was not, because of hot water issues. And when the HPD inspectors came out, the water was hot. This building management is horrible. No superintendent residing on site, and on weekends, no one is available. Tenants organized to let the water run when there was no hot water, and now we have steady hot water. We did not have hot water, especially during the onset of COVID. The building has many violations. Repairs are now being made due to the engagement in the alternative program.
Okay, I'm glad to hear that AEP is helping your building. I'm sorry if there was some, there wasn't an appropriate response during the winter. Again, without knowing the specifics of your building, it's hard for me to speak to your issues. But if there's any additional work you need from AEP at this point, again, please let Palante know the details of your situation, and they can send that over to us. But we do respond to hot water complaints fairly quickly during the winter.
If HPD does repairs in landlord building, why don't they do repair? Why are they not doing repairs in those buildings that belong to the TIL program?
As Alcia said, the TIL program isn't under my jurisdiction, so I really can't answer any questions on their behalf. But again, Alcia knows who to contact at HPD regarding those issues, and so you
Yeah.
should let her know.
Yeah, so for those of you that are on the call, the TIL program are city-owned buildings that the city owns. They are under a different department that is not under Anne Marie Santiago, and they're under it's actually called asset management. And these buildings are have been waiting for repairs for quite some time. However, in I believe it was 2017, HPD did agree to do capital repairs on these buildings as a result of a hearing that we initiated in the city council. But if there are conditions in a TIL building, the first thing is obviously contacting the board, which is the Tenants Association leaders. And if it's a building-wide issue, then call us, and we will definitely arrange for HPD to step in and do capital improvements while working with your board. I think, the dynamics of the TIL buildings are different than those of landlords, because the Tenants Association, they're tenants just like anybody on this call. And they're trying to become homeowners. So they basically, the Tenant Association who are managing the building on behalf of the city are doing this for free. With very little money. But if there is an issue with repairs or violations, by all means, give us a call, and we'll be more than happy to arrange a conversation with the deputy commissioner of that department, of the asset management department at HPD. Next question, Robert.
Yes, this is a question in Spanish, and I'll read that, and then it'll be interpreted. Respecto sí, vivo en la calle I'm sorry, vivo en la calle 150, no están dando agua caliente ni calefacción. Calle 150.
What's the building number?
El número del edificio 569 de West 150.
And can they have the person call 311?
And we'll wait to see if we have a follow-up response to that. 569 West 150th.
So, obviously, again, I don't know the specifics of the situation. Certainly after the call, we can go and look at the records we've received, at the inspections we've done. If you can provide additional information to Palante about, what time of the day you don't have hot water, is it never hot water, how long has there been no hot water? Those things will help us in tracking our response and sending an inspector if one hasn't already been there. If you provide your contact information, that's even better, because then we can go directly to your apartment and do the inspection there. So again, you don't have to put all that in the chat. I don't know if people want to put their personal information there, but certainly I'm sure you can reach out to Palante directly after this session.
Good evening. I do apologize. I'm late attending the meeting. I am having a lot of issues at the apartment I am currently renting from. What are my rights since my son is autistic?
I'm not sure that for the purposes of, the housing conversation, there are differences. The Americans with Disabilities, I'm sure there are some, maybe some special items that you may be entitled to or your landlord may be required to comply with. I am not extremely familiar with those, but certainly if you let us know, what it is that you're looking for, we can, or you can reach out directly to the mayor's office for people with disabilities to find out what else you may be entitled to under the laws that they enforce.
This might be weird to you, but how many tiles on your floor need to be broken for them to replace the right way? It was replaced once and they put it on top of the old tile. Should I be concerned of cracking in the tile on the floor and wall?
If you don't think that the work was done properly, you can certainly file a new complaint, and if the inspector agrees when at the time that he or she is there, they will issue a violation. Primarily, that wouldn't be an emergency violation unless it really provides a cut hazard, right? So if the tile is damaged to the extent that you're going to, if it's a bathroom tile, for example, and you're going to cut yourself, the inspector may write a Class C violation, but generally it wouldn't be. Or if it's an extreme trip hazard, but that would have to be a very extreme situation.
Our building received its COO on January 8th, 2008. That said, we are still without a superintendent and we have the original washing and drying machines. Landlord refuses to hire a super for the 22 apartments nor replace the washing and drying machines. Landlord received money from CoinMac on a monthly basis.
So, in terms of having no superintendent or janitor, you can file a complaint with 311 about that, and it will come to HPD. In terms of your washer and dryer, those are not required by the housing code. If you are a rent stabilized tenant, and those amenities were provided to you at the time you moved in, but are no longer working, I think you can file for a rent reduction with the state, homes and community renewal. If you are not a rent stabilized tenant, I'm not sure what tools are available to you to have the owner replace those. And I would think that unless they're actually broken and not usable, there's no law that requires them to replace washers and dryers on a certain schedule.
My dilemma is not with the landlord, but with the superintendent's wife. The last job I lost was going to pay me $65,000 a year. She also obtained an order of protection against me. She works the front door, so there's no passing by her. She did it to financially disable me from paying rent, and the 3-bedroom apartment would become hers to do as she pleases. My question is, can HPD help me protect myself from this happening again? Also, who can I talk to?
Yeah, I think the person who's asking that question should really contact Palante Harlem. You could call us at 212 491 2541. I think it's important that that we stay focused on landlords behaving badly and what this agency can do. Because there's a lot of questions, and I want to make sure that we make the best time or the best use of this time with Lynette and with Anne Marie Santiago. So let's focus on this part. But if it's nothing, if it's outside of code enforcement, if it's outside of taking a landlord to court, if you guys can just give us a call at Palante, and we'll be more than happy to do an intake with you over the phone.
What happens if the landlord agrees to something during a conference but seems to renege on a lot of items before a stipulation is signed and the pretrial date? Our building is in AEP.
When the person who's asking that, could you repeat the question, by the way? Repeat it again.
What
What's
happens
the
if the
settlement?
if the what happens if the landlord agrees to something during a conference but seems to renege on a lot of items before a stipulation or stip is signed and the pre-trial date our building is AEP?
Well, I think not on the defense of the landlord, but I think anybody can change their mind. If you have an attorney, you should have the attorney fight for you to make sure that the landlord does not go back on what they wanted to agree until that stipulation is signed. He can change his mind, and you can change your mind all you want. If you want to go take the case all the way to trial, by all means, you can do that. And the landlord can, continue to offer different settlement offers to you until something is, agreed upon. But yes, the landlord and like anyone else can change their minds on whatever is promised. If it's not in writing, it doesn't exist. So, unfortunately, that is the truth. Next question.
Next question is, who monitors how the landlord is making the repairs? The landlord does not do the repairs professionally.
I think that the first thing here is that the landlord's making the repairs. Depending on what type of repairs it is, there are cases where he needs a permit. There are cases that he does not need a permit. But in terms of who's overseeing the landlord, I think, guys, you need to understand that this is his building. You're renting an apartment from the landlord. But if he's what he's doing is not per code, meaning by the law, proper repairs, making sure that you don't get affected with debris and things like that. If the repair that he's doing is shoddy repairs, your option would be either A, to take him to court, B, organize the tenants to take him to court, or C, file a complaint with DHCR to get a rent reduction. Again, I'm a very big, I know I sound like a broken record on this, but the one thing that I know motivates the landlord to do things right is when you hit him in the pockets. And the way you're going to hit him in the pockets is through the courts, through calling 311 through HPD, and also through DHCR. Once he knows that you are serious about getting these repairs done adequately, I guarantee you that he will change his or her tune. Next question.
Yes. Well, not a question, additional information to file a court complaint. If you cannot afford it, you file an additional form and it's free. $45 filing fee is waived.
Mhm.
Another comment, the fines are too low. A better incentive, make the penalties criminal, not civil.
Right. We need to go to city council on that one. So yes, I agree with that. Absolutely.
Thank you for selecting our building. Not a question, thank you for selecting our building to be AEP in 2021.
What building is this?
What building is this? Let us know and we will get back to that. Can the landlord show up for repairs without prior notification after 8:30 p.m.?
No. The landlord is required under the law to do repairs during business hours. Unfortunately, that doesn't always work for the tenant either, though. So, if you need a repair, when the owner is willing to offer to have people come after hours, that's certainly allowable. But the owner really does need to give you advance notice of that, and the requirement is for it to be during business hours. So
I
they
just wanna,
can't.
yeah, I just want to add, unless it's an emergency.
Correct. Correct. If the water is imminently falling, or your sink is leaking into the next apartment, certainly your landlord can come in. But I'm assuming that the question was about regular types of repairs.
222 St. Nicholas Avenue in Harlem is part of AEP 2021.
What's the building address again?
222 St. Nicholas Ave.
Excellent. I think that with this program, it's important that the tenants engage with the coordinator to make sure that their apartments are inspected And sometimes the landlord is going to probably is going to try to intimidate you to let him in with the inspectors, but in reality, it's not the inspector's not there with him. He just wants to be nosy and he wants to come into your apartment. And my question to Anne Marie is this: Anne Marie, when an inspector comes in, which is a specialized inspector with the AEP program, it's not just any regular inspector. There's someone actually
Mhm,
dedicated to the building.
mhm.
Um, is the landlord? Can a tenant stop the landlord from coming in with the
Of
inspector?
course,
Okay.
absolutely.
That's very, very key because we always hear that they're like, no, 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 give me access. But in reality, is that he's trying to get in with the inspector from the AEP program.
That is up to the tenant. Just because the inspector's there doesn't mean that the landlord or the super can enter with the inspector.
Great, great.
We did have a question about accessing a recording of this event, and I believe Jakari will be able to provide that information in the chat. Um, how can I get in contact with Housing Court?
Oh, that's I don't have the number handy, but you know what we'll do? We'll give you guys the phone number where you could call per borough because it's also, the numbers vary by borough. So, but we'll follow up. Jakadi will send a follow-up email to all the program participants for tonight, and you'll have that information as well as a copy of our apartment inspection checklist. This is the list that we would recommend that you guys complete if there are conditions in your apartment that need to be fixed, and we recommend that you share that with your landlord. That very same list can then be used for other things, such as doing the 311 complaints, and obviously giving that list to our office so that we can assist you in submitting a service complaint for a rent reduction to your apartment with the state. Um, the folks on Zoom today with us are with the city. So the city issues violations, the city fines the landlord, but there's another enforcement group, which is called DACR. For some of you that are new to DACR, these guys are the ones that oversee the rent laws.
Does HPD address conditions to the building facade?
Most building facade issues are under the jurisdiction of the Department of Buildings. However, our inspectors do, as a matter of routine, as part of their regular process, before they go into the building, check the facade for any obvious defects. So if there is a broken fire escape, for example, or there is a lintels, the piece above the window that's falling, or obvious cracks in the facade, the inspectors will write a violation and refer that issue, especially the cracks, to the Department of Buildings because they are the experts on the structure itself. If you file a complaint with 311 about the facade, it will most likely go to the Department of Buildings.
Mhm.
What can I do next? I am afraid of my landlord. He verbally attacks me when I'm alone and is aggressive even in front of HPD inspectors. He doesn't seem to care that HPD has issued Class C and B violations. He has also been summoned by the state to issue a lease renewal, but still hasn't done a thing.
So if you call 311, 311 can get you to the Tenant Harassment Task Force. This is a separate division from the one that Anne Marie mentioned. With 311, if you explain the situation that your landlord is harassing in that manner, the mayor's office has actually a contact. Alternatively, if you give us a call, we have a direct line to someone at that in that division, that department, that can also further assist us. In terms of the lease renewal, that DHCR issued an order saying that he has to give you a new lease. If the landlord is not complying, we can file what's called a notice of non-compliance. And it's a very easy application that our office can assist you with. And then the landlord will be fined if he does not give you your lease and pay a penalty. I believe the first penalty is $250, but after that, it turns into the thousands. So please give us a call and we'll be more than happy to help you file a notice of non-compliance with DHCR.
How do you know who the coordinator is?
For AEP, that question is?
That was
I
that was
assume
the,
so. I assume that that's the question. So your coordinator should have reached out to you when the building first came into AEP. If they didn't and you don't know, what I will do is make sure that I'll see if she already has a link to AEP, but we'll make sure to get her if she doesn't already have the general number, and you can call there and they will identify who is your community coordinator. And you should keep that number handy, for yourself and for your fellow tenants.
This is a question for Miss Parker. I am a tenant at 222 St. Nicholas. Can you be present at the pretrial in 2 weeks? The person gives their name. I'm not sure if I'm.
Oh, I'm sorry, I couldn't hear you. Can you speak
Sure.
up a bit?
The question is for Miss Parker. I'm a tenant at 222 St. Nicholas. The person identifies himself in the question, and I'll leave it up to Elsie about whether to provide the information. Can you be present at the pretrial in 2 weeks?
Can I be present at a trial?
At the pretrial.
The pretrial. I'm not. Is this regarding the tenant action case?
We'll see if there's a follow up to that question. That was the extent of the question.
If you email me the information, I can tell you who the attorney is, or if we do have a case in court on it.
And another question about, can I please schedule a meeting since I need help?
Call Palante Harlem to schedule a meeting. But the meetings, just so that you understand, we're still not seeing people in person. The meeting would either had to be done through Zoom or over the phone. And we would need for you guys to send us the documents prior to the meeting. But we're more than happy to help you. It's just you're not going to be able to sit in a chair and meet with us one-on-one until we get a better handle of this global pandemic. But we're here to help you. Sure, the number is 212-491-2541.
Are landlords supposed to clean the exterior window ledge of bird droppings if the windows are such that it is not possible to clean it from the apartment? How to ask about how to get that cleaned or maintained? This has never been addressed in the 20 years that I have lived in my building.
And I have to say that I have never heard that question, so I will have to do some research to find out for you what the answer is. Yeah, I do not know.
It almost sounds like it's a Department of Health issue, right? If
Yeah.
it's droppings.
Right.
What probably makes sense is for them to call 311
and see where that goes.
Right?
Yeah.
See where that goes.
Yeah.
I never heard it either.
Right.
But I can see, the pigeon droppings. I like to call them the rats with wings. And it could be annoying. So I sympathize with the person asking that question. I think it's 311. I mean, unless you have any ideas, Anne Marie or Lynette, what do you think?
I don't have any additional ideas on that. I can try and ask around and see from folks at Health if there is a way to get an enforcement on that. If whoever submitted that could give us just some more information about whether they believe that this is building wide or just affects their apartment too, that would be helpful.
So Robert, if they can give you the information, can give us information, we'll reach out to them after we do a little bit more research. That's what I love about these Zooms. We always get that one question that we never thought of. And it just, you never stop learning. We just, excellent. Next question.
That about brings us to the conclusion of a fabulous list of questions.
Wonderful. Well, I have one more question for Lynette. Lynette, so let's say I'm a group of, I'm a tenant, right? And I have a terrible landlord, and all of our tenants are fed up, and we can take it no more. They can petition, they can ask HPD for help for an Article 7A. Can they still do that during this environment?
Yeah, I mean, the 7A cases are cases of It's a drastic remedy, first of all.
Right.
And it's a case of last resort. So
Right.
meaning after you've gone through the process of other court cases, maybe we've done comprehensive cases, tenant action cases, access warrant cases, then we say, let's see if we should take a different direction. And we look at the violations, the condition of the building. The condition of the building has to be very poor. No heat, no hot water, just everything. The roof is bad, the plumbing is bad, the building is really, really in bad shape.
And it has to be recorded. It's not just by mouth. It's like it
Yes.
has to be like I
Yes, you have to have violations to substantiate how poor the conditions of the building, is. So what we can do, HPD can initiate the 7A case, or if you have 1/3 of the tenants can also bring the case on their own. And getting a 7A is not an easy task, as you know. It's very complicated, because what we're looking to do in a 7A case, we're looking to take away the control and management of the building, not ownership, control and management,
right.
from the owners, and put in an administrator to run the building. If he is or she is appointed to correct the conditions at the building, and essentially to make the building safe and sound, and to stabilize the building. And what's important, and what's really, really important for the program to be successful, is that the tenants have to be aware that once the administrator comes into the building, that it's really important that the tenants pay the rent. Just because the condition of the building is poor is not a legal excuse not to pay rent. And what we want to do, we want to get the income coming into the building, because then the administrator can take that money and make the repairs in a proper way to help to stabilize the building.
And we know that in buildings where tenants are on a rent strike, for example, and they may be seeking a 7A, to start collecting that money during their rent strike, so that as soon as the 7A is appointed, they have a pool of money to start with to make repairs right away, right? Because the administrator may be able to get additional funding from the city to do major repairs, but that takes time, So every city process, unfortunately, where you have to get money is going to take a long time. So if the tenants come to a 7A, they've been on a rent strike, they want to get a 7A gets appointed, they can immediately give that money to the 7A, and the 7A can start working on their behalf.
And that's exactly what we did. Our grassroots buildings, before anybody taught me how to do this thing called Palante, we did file an HP action. And the landlord bluntly told HPD and the judge, I'm not going to make any repairs because they're not giving me the rent. So we filed that, what's called an Article 7A. And then what we did was, if each building, we have 3 buildings that we coordinated, each building had a treasurer, and the treasurer, everybody deposited the rent to the treasurer every month, like clockwork. And when a 7A was installed, which took us a year, we gave the 7A administrator $500,000. And immediately we got a new boiler.
That's excellent.
And it was right on the clock. Everybody paid their rent, because it's one thing about if we're trying to get money or not have to pay the rent. Another thing is that what we're fighting for, if it's for repairs. And as an organization, we fight for repairs and legal rents. But that is exactly it. When I'll never forget when I went to HPD and Broadway, I specifically said, I need help because my landlord is absent. My landlord left the property. So it has to be something very severe. And I know that it's not an easy task, because a judge basically takes away the management responsibilities from the landlord, but the landlord still keeps the building, right? So of course the landlord's going to fight. Property value is high. But as I always tell people, don't ever underestimate the power of the tenants in any building. So if your landlord is misbehaving, what I would recommend, just from my own experience now, before you think about the 7A program, is give us a call. We'll come over. I don't know if you notice, for those of you guys are online, all of our folks from Palante, the team, is actually on Zoom right now, and they're listening to you. If you give us a call, we will come to your building. We will do our own roof to cellar inspection. And then we find that an inspection by HPD is deemed, we can contact someone at Anna Marie Santiago's team, and they will come as part of the PPI program, the Proactive Preservation Program, and they'll do a roof to cellar inspection. Then if they see something that's not kosher, that we know we got some problems in the building, then they send in the inspectors, another group of inspectors. Then when those inspectors come in, and I'm going to give it to them, Anne Marie, the way I learned it, right? Then HPD has a what I call a come to Jesus conversation with the landlord, and they tell the landlord, do you need money? Because we got these conditions. Do you need money? And of course, the landlord's going to say, no, I'm fine. I don't need any money, because we know he just wants to keep the money, right? HPD will offer him loans, right? Just in case. But he's going to say no, he doesn't want it. So then HPD says, okay, so you don't need our money. You have until such and such date to make these repairs. If not, we're going to send this over to Lynette. That's basically it, right, Lynette? Look at her. She's an attorney, so of course she's looking at me. But this is the way that we explain it to the tenants, because there is help. Once you call 311, there's help. If you call local nonprofits like Palante, there is help. What needs to happen though is that the tenants need to want help. And if the landlord's ignoring you or trying to threaten you because you call 311, give us a call. We love fighting landlords, especially on the tenant's behalf. So Robert, are there any more questions before we?
Yeah, just a couple. Con Edison refuses to read the meters in the basement due to consistent flooding. How can this be addressed to stop estimated bills?
So you can certainly call about the flooding to HPD in terms of that could be emergency condition if the flooding is bad enough. I can't speak on behalf of Con Edison or their policies, but that flooding needs to be addressed regardless of the Con Edison angle.
I have good evening. I have heating issues. I'm the only tenant complaining about the heat issue. I've reached out to the landlord several times in the past. As per landlord, air conditioners in the bedroom and living room need to be removed to avoid drafts. I've sealed the draft. However, heat is not turned on during the day or throughout the night. Heat is turned on only if it feels 16 to 28 degrees outside. Anything in the 30 to 45 degree range, heat is not turned on.
Okay, I mean, obviously the landlord should be providing heat whenever during the day in the heat season, the landlord is required to provide heat at 68 degrees. At night, it drops down to 62 if the outside temperature is below 55. So there are requirements that the owner has to meet, the landlord has to meet regardless of the outside temperature, especially during the day. So again, we can look at what complaints you filed with 311, what HPD has done in the past. Without looking, I don't know if we've already gotten civil penalties against the landlord, but I would encourage that person to continue to file complaints if heat is not being provided.
I had the same issue, and the landlord, follow-up comment, wouldn't fix it once I was in contact. Over a course of a month, they scheduled a plumber to fix it within a few months, and now I have heat. And a final question or a comment about Section 8 case being lost and request to get back to Section 8. I can forward that to you.
Yeah, if they can call Palante regarding that, the Section 8 question, that'd be terrific.
And
So is that the last question?
That does conclude.
Well, guys, thank you so much for joining us. Robert, if you could do the survey for us like you normally do every week.
Sure, Giacotti, if you want to bring that up.
In the meantime, I wanted to thank Lynette Parker and Anne Marie Santiago. You guys, wealth of information. Thank you. We consider you guys partners in the fight for unscrupulous against unscrupulous landlords. So thank you for joining us. Thank you for helping us out, and always, being there in the event that we need help, and we need someone from the inside to give, like we could give a call. We really, really appreciate this. With the tenants that are on the line right now, we just want to point out that, especially the night tenants, that next Friday, the 16th, I think next Friday is the 16th. We're actually going to focus on NYCHA, administer Section 8 vouchers. On April 23rd, we're going to talk about major capital improvements with the Deputy Commissioner Woody Pascal. And on April 30th, we're actually going to speak on eviction moratorium, whether it's extended and what to expect next. So look forward to seeing you guys on the 16th, and have a great weekend. Thank you, everyone.
Thank
And
you.
Thank you.
do continue to vote in that poll while you're still here.